So we're going to play a game called How Many Professors Does It Take to Move Chairs? And the answer is more. We are so delighted to have you here today. We're going to start off our conference with a panel that looks at the law governing legal capacity, legal tools that can be used to limit or realize the exercise of capacity, and our evolving understanding of the aging brain and decision-making processes that can inform all of this. So we have a series of presentations. We're going to go a little bit out of order, moderator's prerogative. I will keep everyone to 10 minutes. And we're going to start with Professor Duke Hahn. Duke is a diplomat of the American Board of Professional Psychology and Clinical Neuropsychology, a fellow with the American Psychological Association and the National Academy of Neuropsychology, and a professor of psychology, family medicine, neurology, and gerontology at the University of Southern California. Among other roles, he directs an research lab that's doing really interesting work on cognition and aging. And his full bio can be found online. It's impressive. Duke, will you start us off?
Really great to be here. MT said I should share that my mom told me I had to wear a suit because I was coming to Harvard, an Asian mom. So she also was very proud of the fact I was coming here and wants a sweatshirt for everything that Harvard has been standing for. So thank you for having me. So I'm going to share a little bit of our work, focus on trying to understand financial decision-making in older age, and in particular in certain older adults where it seems to falter or might not be as optimal. And a lot of this, I think, might be relevant to undue influence. And so I tried to do some research for the first time in the legal world, which is not my world. Excuse me. So forgive me if this is a bit shoddy, but I found this law in California, which seemed to define undue influence. And then this was modernized in 2014, identifying particular points that might be salient to consider when considering undue influence. But it might be understandable that as we grow older that undue influence might be an issue. We know that as we grow older, certain brain regions seem to decline with age, and this is part of normal aging. And obviously in pathological aging, this could be even more severe. And we know, generally speaking, that as we lose brain, our cognition seems to go down as well. That makes sense. A lot of our work is focused on this space, so we do see that even in mild cognitive impairment in older age, that this is associated with worse or poorer everyday financial decision-making, and us and a number of other labs have found this. But we want to try to understand this a bit better. So there are clearly situations where older adults don't seem to have poor cognition, but seem to be making poor financial decisions or decisions in general. One way that we've been trying to understand this is using neuroimaging. We know from seminal work from the National Institute on Aging and at the campus at NIH that we can see brain changes that are happening with neuroimaging ahead of any noticeable cognitive impairment. And so the same premise goes to decision-making. We might be able to see brain changes that are associated with changing financial or just decision-making in general associated with brain changes. So one important point, background that I need to highlight when covering this is this idea of cognitive decline in aging. So not all older adults are going to cognitively decline. There's this presumption that all will, but that's actually not the case. There's actually variation that happens. And most people imagine this singular sort of declining line, or at least a lot of the research seems to suggest this with age. If you look at this at the individual level, it actually looks more like this. So there's a lot of up and down when it comes to cognition, and there's a lot of variability. Some people go up, some people go down, and this is actually data that runs until people die. This is until death. There's a decline right before death that seems to be pretty clear, but there's a lot of variability. So if you statistically control for all of the pathological things that happen in aging, so this is not age, these are the pathological things that happen in aging. So accumulation of amyloid and tau, microvascular changes. These are things that go wrong in aging. It's not age. These are pathological aspects that happen more prevalently in aging. If you statistically remove that from the equation, what do you have when it comes to cognition? You have a flat line. Cognition does not decline with age. It declines with age-associated neuropathology. And so I think that's just an important point to make. It does seem to decline right before death, and that seems to be there very slightly, but in general, it's the pathological aspects that are associated with aging that explain cognitive decline. We know that age-associated neuropathology impacts very specific brain regions, and this is in the context of Alzheimer's disease as an example. So our working model is that as these age-associated neuropathologies accumulate, they impact brain regions that therefore impact decision-making. This could help explain the variation why certain older adults make poor decisions and others don't. So one paper I want to highlight from our lab, which got a lot of press recently, was this paper identifying from my graduate student, led by my graduate student, that the entorhinal cortex is associated with financial vulnerability in older age. And the entorhinal cortex is important because it's commonly known as the first brain region affected by Alzheimer's disease. So these are non-cognitively impaired older adults, but we're showing less thickness in the entorhinal cortex at a brain region very sensitive to Alzheimer's pathology associated with financial vulnerability. This was actually picked up by CNN, and I'm hoping this works.
Researchers at the University of Southern California believe there may be a new way to spot Alzheimer's disease in its early stages.
Brain regions that are affected early in Alzheimer's disease are also involved in financial decision-making.
Before she died, Jim Clunder's mom, Joan, was showing signs of Alzheimer's, but her decision-making skills around money fell apart years earlier at a huge cost to the family.
If you wanted to estimate how much she was scammed out of her own pocket, my guess would be close to $100,000.
Researchers say they may have found a link between money matters and Alzheimer's. The part of the brain called the entorhinal cortex is a relay station between the hippocampus, which draws on experiences, and the medial prefrontal cortex, which values judgment and decision-making. The entorhinal cortex was thinner in individuals who were more likely to be victims of financial exploitation.
The entorhinal cortex is also the brain region that is affected very early by Alzheimer's disease pathology.
This is something that helps explain why certain older adults may test cognitively normal, but may be showing poor financial decisions. And if this is happening, then I would encourage people to pursue resources on behalf of the welfare of the older adult.
Clunder said his mother had once worked with top executives and even presidents. So when she started making strange payments, he realized something was wrong.
She would never replaced windows in her house that didn't need replacing, or buying a new refrigerator when she didn't need a new refrigerator.
Jim decided it was time for his mother to move to Pennsylvania and live with him. The week before Clunder's mother moved in with him, she bought tickets to go on a cruise to Europe instead. She also visited an ATM and went missing overnight.
So she was gone from 3:30 in the afternoon till noon the following day until someone found her. She stopped at a drugstore and bought a blanket and slept in her car. And that's just not her. The more you're around them, the less you remember them the way they were. And it's hard.
There's more to that if you're interested. It's on CNN's website. So a lot of the work that we do is actually highlight the importance of context and how that actually is important for how the brain develops and how the brain matures in older age. This is something that was captured very nicely by Ed Young, who is a Pulitzer Prize winning author and journalist for his COVID reporting. And this has been an area of focus of our research as well. And a lot of the work that has been done in this space has really focused on very not diverse, not representative samples. And so I've been working with others, such as Dr. Lisa Barnes at Rush, to really focus on different people groups that have been understudied in this regard. And so One example of this work is we really found that racial differences in decision-making are really attributable to the ability or the how equal someone has access to developing financial literacy in regards to those decisions. And obviously that's an access issue. There's historically documented racism in our country towards certain people groups that have not had that access ability. And so a lot of this work also has focused on contextual factors as being important. In work with Mark Lax, who's Chief of Geriatrics at Cornell in New York, we've really tried to highlight that there are a number of factors that contextually, medically, cognitively, and otherwise socially would be important to consider in this regard. And so we've been trying to focus on all of these factors, trying to understand what factors might impact decision-making in older age at USC with our lab. A couple highlights. So obviously, the more physically frail an older adult is, the more they seem to report more financial exploitation. Also, social connectedness is important, but it's not just how many connections someone has. In our most recently published paper, we found that it's really the depth of connection socially that someone has that seems to be protective in this regard. And so you can have fewer connections, but deeper connections, and that could actually be better. So a lot of this work is informed by my mentor, Laura Mosqueda, who's internationally known for her work in elder abuse. And she's really helped me think outside just the vulnerability of the older adult, that there's also the perpetrator and the context that needs to be appreciated. So some final thoughts. So we really see this as a spectrum. It's not really a black and white issue. And we see this also as an intersectional issue. So there are a number of factors that need to be considered, but there might not be any vulnerabilities at all involved. It could be just the perpetrator and the context that's the cause for the exploitation. So with that, I am done. So thanks.
Thank you, Duke. Our next speaker is going to be Leslie Francis, and I'll just note we're going to do the speakers and then we will have discussion. So Professor Francis is the Alfred C. Emery, Distinguished Professor of Law and a Distinguished Professor of Philosophy as well at the University of Utah. She is a true Renaissance woman, writing at the intersection of ethics, philosophy of law, bioethics, health law, and disability ethics and law as well. She also chairs the board of the Utah Disability Law Center and provides pro bono representation for people subject to guardianship. So Professor Francis.
Thank you. So I didn't do slides. There are a few copies of my talking points if you like to see something on paper. So first of all, a double thank you to Harvard, both for what it's standing for and for showing us a wonderful time and putting together a wonderful conference. So thank you. The title of this paper, which is co-authored with Michael Ashley Stein here at Harvard, is Designing a Statute to Enable Individualized Decision-Making in and with Dementias. Now that may seem like a paradox, and I think you're going to hear a general theme in this panel that there's a tension between the law as general rules and the way aging differs in people, as you just heard. So dementias in our title is intentionally plural. It is actually the DSM-5 says we're just using the term for convenience. There are, as a way of grouping together a number of neurocognitive disorders that are characterized by significant decline in a prior level of performance in one or more cognitive domains, where decline is understood functionally. Unlike some other forms of loss cognitively or lack cognitively, for which some of the statutory devices have been designed, dementia is a decline, so there's something to look back to. And typically thought of as a kind of decline found in older age. So what are the goals of statutes to enable decision-making? Well, I think the idea underlying these statutes is to try to figure out how to enable people, when they have capacity, to make provision for how they would prioritize their preferences, their interests, maybe even the interests of others and their values. So what we're trying to do is create legal devices that enable people to tailor the kind of decision-making they would like to have when or if their capacity declines. Now, one of the interesting things about all the new sorts of developments is that we're now able to have much more of a sense for different people what that cognitive decline might look like, if it's likely to happen at all. So what might somebody want to consider facing the possibility of cognitive decline? Well, they might want to think about what sort of condition they may have, because that could make a difference to the sorts of capacities that are expected to be affected, whether it's the capacity to make financial decisions or the capacity to communicate. Those could be potentially quite different depending on the level of decline and the cognitive function that is expected to be affected. Another thing people might want to consider is whether their kind of decline is likely to be associated with behavioral manifestations such as suspicion, fear, anger, withdrawal. They may just imagine that their decline is likely to be associated with suspicion of people they have previously trusted. So then what would you want to think about if somebody changes their designated power of attorney after the decline has begun? Something else people might want to think about is the shape of their decline. Is it likely to be the kind of decline that is insidious? So when somebody's looking at whether there's a treatment refusal or a change in the designation of a power of attorney or the change in the designation of a decision-making supporter, whether there may have already been unrecognized decline. So with, for example, Alzheimer's, often the fact of decline isn't recognized until there's some kind of precipitating event, say the death of somebody that the person has lived with. And another thing that people might want to be considering is all the sorts of social circumstances in which they're likely to be. Are they likely to have support of family? Are they likely to be alone? Are they likely to be living in an institutional setting? There might be very different kinds of provisions one might want to make for these different settings. So part of what we do in our paper is we outline how the current state statutes, which include living wills or advance directives, powers of attorney for health care, powers of attorney for financial matters, supported decision-making, default surrogate decision-making statutes, how these just don't fit individualized circumstances very well. We call them one size fits all. There are gaps. It may be that there isn't in a state good provision for situations in which people have some capacities but don't have others to the fullest extent. There may be inconsistencies. One of my least favorite is that Utah just adopted the new Uniform Decision-Making Act, and we now have two different advance directives for mental health care, one of which is revocable and the other of which is not. What the legislature did was just take one more lovely, shiny thing and stick it in. And that's true in a number of states without any thinking about how, say, a power of attorney might fit with a supported decision-making arrangement. Or when the legislature has thought about these things, they have a one-size-fits-all. So instead of the individual saying, I want, if I name a power of attorney, to take over from my supported decision-making, it's just automatic that if you name a power of attorney after you've had a supported decision-making arrangement, the support arrangement is no longer legally recognized. That's another just one-size-fits-all example. So what do we recommend as possible things statutes could do? One of them is to invite individuals to specify differently, if they so wish, for different kinds of anticipated situations. Or at least, if they do have some kind of an idea of what they think might be happening, to start with that. Another is, instead of having a one-size-fits-all about the relationships among these different devices, including, I should have mentioned guardianship as well, that the individual might be able to specify what takes priority over what. That individuals might be able to specify when they would want transition, under what kinds of circumstances, from, say, supported decision-making financially to a power of attorney, where the decision-making is actually transferred. Individuals might want different arrangements depending on their circumstances. So if they're in an institution, or if their spouse dies, or if they're far away from children or other kinds of support, they might want different arrangements. And finally, they might want to build in provisions for review. And with that, I'm done. Thank you.
Thank you. Our next is a grouping. We get a sort of 2-for-1 deal here. Very excited to introduce Erica Costello and Jessica Brock. Erica is the Associate Director of the ABA Commission on Law and Aging. Prior to joining COLA, she was the Director of Adult Protective Services Office at Indiana, and a staff attorney with the Adult Guardianship Office at the Indiana Supreme Court. Jessica is also with COLA as a senior attorney and chief counsel. Prior to joining COLA, Jessica directed Legal Assistance for Victimized Adults project at Indiana Legal Services. Thank you so much for being here.
Thank you. We're grateful for the invitation to be here. Such an exciting group of people to be among. So our overall point of our paper is that legislative or statutory language about capacity and healthcare decision-making abilities has not evolved or kept pace with scientific understandings of capacity and decision-making abilities. And this creates problems in healthcare settings where legal documents like healthcare powers of attorney are interpreted by medical professionals. If informed consent is the model used by medical professionals to decide if a patient can make a treatment decision, the healthcare proxy documents should also use this model. Additionally, by not updating legislative language as scientific understandings evolve, we are left with unhelpful, inaccurate, and sometimes pejorative statutory language that only serves to perpetuate ideas of ageism and ableism. And we offer in our paper the 2023 Uniform Healthcare Decisions-Making Act as an example of legislation that has been updated to better reflect scientific understandings of capacity and decisional capabilities. Historically, the law's view of capacity and decisional abilities has been binary. Either you have it or you don't. And those without capacity are labeled in the law as incapacitated or incompetent or insane or idiots. Law's view of capacity is typically focused on substitution of decision-making rather than supporting an individual's ability or right to make decisions. The law defines when a person cannot make a decision instead of defining what is needed in order to make a decision. Whereas medicine focuses on the latter, what is needed to make a decision, and this is often called informed consent. We have found that the law continues to use inappropriate bases for determining that a person cannot make a decision. Some examples of these are using in a statute specific diagnoses as, this diagnosis equals cannot make a decision. So for example, in North Carolina, the law still says that if an individual has epilepsy, can't make a decision. If you have cerebral palsy, can't make a decision. Autism, developmental disabilities. Another problem are inappropriate terms like insanity, senility, and mental deficiency. Some statutes also use things like incarceration as a basis for inability to make a decision. The medical profession is more readily able and willing to recognize capacity as a fluctuating continuum than the law is. Some states have made efforts to reform and remove unhelpful language in reference to capacity. For example, many states have tried to remove the word idiots in constitutions when referring to people who cannot make decisions, and removed the use of medical diagnoses in their statutory definitions of incapacity. The first Uniform Healthcare Decisions-Making Act was developed and adopted in 1993. And in that adoption, that act uses, a lot of laws will list terms and say this term means this. They'll have a definition section in addition to the laws. And that's the format the 1993 Act uses. And the definition of capacity is in line with that for medical informed consent. The 2023, the latest version of the Uniform Healthcare Decisions Act, takes a different approach to capacity. It's not a definition section. Instead, it takes several sections of the code to talk about capacity, including the statutory parameters to define what is needed to make a decision, who decides if a patient can make the decision, and the means for the patient to object to a capacity determination if they disagree with it. And this is the result of the Uniform Law Commission's forethought to convene a group of medical and legal professionals in the drafting of this act.
So one of the things that we think is really important about the updates to the 2023 Uniform Healthcare Decision-Making Act is getting to the very nature of why people are not looking at using advanced healthcare decision documents. to kind of look into that answer, the committee looked at, including legal and medical experts as part of this process. And to kind of oversimplify the answer, some of the things that were brought to the attention of the committee were that these documents were useless if healthcare professionals can't make sense of them or use them in their work. If the medical professionals don't know how to use them to make determinations of capacity within the legal framework, what good are these documents in preserving autonomy or decision-making practices? Another major stumbling block in the use of healthcare advance directives stem from the fact that they are modeled after property transfer documents, meaning that they are transaction-focused. The document is viewed as a transaction where one person gives another the ability to make decisions in their place. While this is part of the purpose of a healthcare advance directive, the real focus is on preserving the healthcare decisions and values of a patient when they are unable to communicate them for themselves. Therefore, the document must do more than just hand over decision-making authority. It needs to provide space to communicate decisions and values to those future agents. But as you know, progress is very slow, and only 2 states right now have adopted the 2023 Uniform Healthcare Decision-Making Act, that being Delaware in 2024 and Utah this year in 2025. So we're kind of looking at the fact that we now have all of these new developments with the Uniform Healthcare Decision-Making Act updates, which we believe offer a very promising blueprint for legal and legislative reform efforts, addressing many of the limitations in current state laws and concerns articulated by medical and legal experts, moving away from outdated terms and a lot of these binary capacity evaluations and standards towards a lot of these legal standards and updates that are more in line with modern understandings of what capacity is as a continuum that can fluctuate, and that legal systems can better support meaningful healthcare decision-making. And continued legislative efforts and adoptions of this model law are necessary to move forward with reform efforts, particularly in the areas of capacity, and as have been mentioned on our panelists, and the areas of guardianship reform.
Thank you.
Thank you.
Thank you very much. Our next panelist is Julia Duffy. Julia is a former lawyer and government policy advisor who teaches and researches health law and ethics at the Australian Centre for Health Law and Research at Queensland University of Technology in Brisbane. And we're so happy she made the trip.
Thank you very much. Very honoured to be here, and thank you for inviting us all here to Harvard. Let's see, this is my... Okay. Today I'm here to talk for myself and on behalf of my colleague, Professor Shih-Ning then, on decision-making by, with and for people with age dementia. Australian laws bridging the divide between supported and substitute decision-making across regulatory systems. Supported decision-making has been widely promoted as an alternative to substitute decision-making, especially guardianship or conservatorship, as a way to recognise and uphold an adult's civil right to legal capacity. Supported decision-making refers to practices and laws demanding that people are supported by family, friends and others to continue to have legal capacity to make decisions about their own lives, including people with cognitive impairment associated with dementia. However, we argue today against a simplistic binary framing of supportive versus substitute decision-making, as many of us do, it seems, advancing what we have called elsewhere the principled approach to reform that firstly provides a continuum model of support and secondly spreads the responsibility for change from guardianship systems to include other service systems with which people interact on a daily basis, including systems regulating aged care. We will explain this by reference to policy development and legislative reform in Australia. A binary framework for reform sees supported and substitute decision-making as potentially mutually exclusive and antithetical practices. In contrast, the benefits of the so-called principled approach are that it promotes supported decision-making outside of, but also within guardianship or substituted decision-making relationships, and recognises that decision-making happens along a continuum of supports. This means that even if a substitute is ultimately held legally accountable for the decision, the adult's human and civil rights can be upheld if the process of arriving at that decision incorporates support practices and respects the adult's will and preferences according to a set of overarching principles. This recognises the actual decision-making vulnerabilities and disadvantages of people with dementia, while also respecting their residual autonomy. It reflects research on how decision-making is done in the real world, where abstract distinctions between supported and substitute decision-making have proven not to align with the experiences of adults and their family members, workers, and other supporters. It also accounts for the typical presentation of dementia symptoms as leading to day-to-day or hourly fluctuating of decision-making capabilities. Importantly, it disrupts the normative framing of support decision-making as inevitably upholding rights and substitute decision-making as always rights denying, no matter the behaviour of guardians or supporters. We suggest that undue focus in policy development on formal legal recognition of supporters reflects a counterproductive binary approach. Since 2010, most of Australia's state and territory law reform commissions have recommended major changes to guardianship laws, and the Federal Law Reform Commission has recommended changes to laws regulating disability services and aged care. However, if we focused on the single mechanism of legal recognition of formal supporters, progress would be gauged, we think misleadingly, as minuscule. Legal recognition of that specific role has been adopted only by the state of Victoria and by the federal government in its new Aged Care Act, yet to commence on November 1st, 2025. There is little data on the Victorian supporter model, but that which is available shows that appointment of supporters is rarely done. Various reasons have been suggested for the low numbers. Often there may be family conflict or concerns over abuse and neglect, so that the appointment of a supporter won't meet the adult's needs. Other reasons are that family are unwilling or maybe unsuitable to take on the formal supporter role, or the adult may be socially isolated with no supporter available. Under the new Aged Care Act, for people accessing subsidised aged care services both in the community and in residential accommodation, supporters will be able to be registered with powers to communicate a person's will and preference, access their confidential information, and generally support older adults in decision-making on aged care. So what are the benefits, but also the limitations of legally recognising formal supporters? Well, it can be one important step towards cultural change, with also the delineation of the supporter role providing some certainty and transparency for third parties. However, there are limitations. Family, friends and guardians can already obtain supporter powers with the person's consent. Also, an older adult won't always have a person ready to step into the supporter role. Nina Cohn and others have also pointed out that immunities for supporters that protect a supporter from liability for acts done in good faith actually detract from the legal rights of the adult supported. Legal recognition of supporters also risks widening the net of regulation and legitimising a supporter's power in the same way that guardians' roles have been legitimised in the past, whether or not an ostensible supporter is upholding the person's rights. For all of these reasons, formal legal recognition of supporters must be only one component of a wider principled approach to supported decision-making, if it is to have a positive impact on the lives of people with dementia. As I said, in Australian jurisdictions, recommendations for legal recognition of supporter roles has had little take-up. However, there have been broader legislative reforms in guardianship and healthcare decision-making legislation, which include, importantly, inclusion of overarching human rights object provisions, requirements to appoint guardians only after supported decision-making has been attempted, functional capacity tests, and prohibitions on guardians being appointed unless there is actually a need for a decision to be made, obligations to provide supported decision-making within the substitute decision-making relationship, moving away from best interest principles towards respecting or following an adult's likely or actual will and preferences, or as a last resort, promoting the adult's personal and social well-being, and recognising dignity of risk by allowing for a high risk threshold before an adult's will and preferences are overridden, for example, only to prevent risk of serious harm. Unfortunately, there has been no systematic evaluation of these reforms. However, reviews of some of the published decisions in the states of Queensland and Victoria reveal that tribunals follow a least restrictive approach when considering whether or not to appoint guardians, and also in appointing guardians chosen by the adult. But it's not just legislation in the guardianship area that is mandating support decision-making. The new Aged Care Act is also now embedding support decision-making requirements for workers and other actors in aged care. The Aged Care Act prescribes new strengthened aged care quality standards for service providers, managers and workers, which now recognise and promote support decision-making. For example, they recognise adults' right to make decisions about aged care with support and to live the life they choose. Overall, providers and aged care workers must recognise the rights and respect the autonomy of individuals and are required to support individuals to exercise choice and make decisions about their funded aged care services, and provide them with support to exercise choice and make decisions when they want or need it. Together with an accompanying code of conduct for workers and providers, these quality standards recognise that not just family and friends may be decision supporters, but that members of the workforce may be called upon to fill that role, especially for everyday decisions. This is particularly so for socially isolated older people whose main contact may be with their daily support workers. The inclusion of support decision-making obligations in these standards and code of conduct demands education and upskilling across the workforce, including management, and which could lead to a significant move to a rights-based culture. But beyond legislative reform, appropriate funding of services and investment in training and education around support decision-making practice is essential, as is monitoring and evaluation of the impact of reforms. In summary, the principled approach to support decision-making is proposed as a constructive way to shift the focus of reforms from being underpinned by binary framing of decision-making as either supported or substitute. It instead allows for continuum supports outside of and within guardianship and across regulatory systems, reflecting the way that older people make decisions in the everyday world. Thank you very much.
Thank you. Last and certainly not least, we have Hezzy Smith, who directs advocacy initiatives here at the Harvard Law School Project on Disability. He also works very closely with self-advocacy and disability organizations around the world, including in support of the Convention on the Rights of Persons with Disabilities, which I am sure is going to feature in your remarks.
Well, don't give it all away. Hello, everyone. Thank you for the opportunity to be part of this really invigorating discussion, and I really enjoyed reviewing the papers and some of the ideas that are being put forward. I also appreciate the smidgen of irony here in talking about issues of capacity, because as you will all witness, I am uniquely at this moment dubiously qualified to talk about capacity, as my own capacity has been diminished after a couple of days of sleeplessness. We just brought my baby boy home yesterday from the hospital. So thank you, proud dad moment. But as Professor Cohen alluded to, my role at the Harvard Law School Project on Disability and my previous work on disability rights is informing my remarks and the thrust of my chapter, and I'm focusing on how advances in international human rights governance with regard to the right to legal capacity of people with disabilities, specifically in the Convention on the Rights of Persons with Disabilities, which I'll refer to in brief as CRPD, can and should or should not inform some of the work that is just, entering a new phase, let's say, with regard to strengthening the international human rights framework with regard to the rights of older persons. On April 3rd, the United Nations Human Rights Council passed a resolution, not a revolution, a resolution that is jumpstarting the treaty negotiation process for a new human rights treaty for older persons. This is the culmination in many ways of 14 years of work of the United Nations Open-Ended Working Group on Aging, and it kind of obviously, chronologically, follows the UN Convention on the Rights of Persons with Disabilities, so the CRPD. And invariably, because the disability rights movement made it into the international human rights governance framework before older persons, some of the lessons, some of the issues surrounding legal capacity and the how to balance the competing interests around how to deal with issues of diminished capacity are going to be informed by the developments with regard to folks with disabilities. With regard to CRPD, just some brief notes for those who might be less familiar with the Treaty on Disability Rights, the CRPD. Article 12, which regards protections for the right to legal capacity for people with disabilities, was the most controversial provision of that treaty. Far and away, by just one measure, it received the vast majority of reservations, understandings, and declarations from states parties who ratified the CRPD, which is a fancy way of saying for all the popularity of the treaty, which has more than 190 states parties currently. A lot of states parties ratified with some provisos, some reservations about the extent to which the right to legal capacity framed in the CRPD would obligate them to change how they regulate these issues in their domestic frameworks. The states parties' kind of reservations about what kind of transformational change in how we regulate the rights to legal capacity of people with disabilities was made readily apparent with the adoption by the committee that oversees implementation of the CRPD in 2014 of their first general comment, so some normative guidance as to the scope of states' obligations pursuant to Article 12. And in that general comment, the committee, I would say, threw down a gauntlet. It made very clear that people with disabilities have been subject to egregious human rights violations as a result of legal capacity restrictions. And it made it very clear that from a human rights perspective for the committee, that states will have to do wholesale transformations of their substituted decision-making regimes in their home countries in order to usher in, as Julia was mentioning, regimes of supported decision-making. So rejecting the general comment, rejected the notion that there are haves and have-nots with regard to legal capacity, and but in an interesting way, kind of retained that binary and just moved everyone from who might have been in the have-nots box, who because of their disability, into the haves box. So the general comment adopts what some call a universalist approach to legal capacity, and asserts that every person with disability has legal capacity and has a right to exercise that legal capacity, and importantly, to receive all the supports that they need in order to make that happen. This could have, been, it's been criticized, and the committee might, have just been doing some savvy negotiation, adopting a maximalist position, because on some level they might have known that if they don't stake their flag really far downfield, states parties won't adopt some of the transformative changes that would be necessary in order to better preserve the rights of people with disabilities to make their own decisions and to direct the course of their lives. It also might just be, kind of what it promises to be, which is just a clarion call for a revolutionary transformation on, all these regimes of substitute decision-making that people with disabilities have been disproportionately harmed by. Whatever the case may be, in my chapter and for, kind of to add to this discussion, I would just kind of like to, I don't have a full-on principled approach, so I'm a bit envious, but hopefully kind of the addition or the supplement or the innovation that I would like to offer for consideration is that both with regard to the general comment number one, that for persons with disabilities and their right to legal capacity, and also for the consideration of those who, governments and civil society alike who are going to be engaged in the older persons treaty negotiation process, that there be a clearer lane carved out for delegated decision making. So instead of kind of maintaining a binary framework, which in some levels, is helpful, that a third lane could be more clearly articulated in favor of delegated decision-making. Delegated decision-making for many here present might not be that much, might sound like that much of an innovation. It's reflected in the powers of attorney statutes for healthcare and otherwise throughout the United States. And it just refers to the voluntary transfer of authority, either pre-planned or in an ad hoc manner. But in the general comment, that is the role of what a delegated decision-making authority is really not clear. In one of Professor Then's pieces, she mentioned that a delegated decision-making authority would not be compliant with the CRPD and didn't really kind of assumed kind of on its face because of that binary, that delegation, because it kind of implies in some cases a voluntary restriction, so to speak, on legal capacity would not be CRPD compliant given the general comment one and the committee's guidance. I'd argue that there may be some ways to reconcile delegated decision making within the existing construct that we've been given within the general comment number one, but more kind of I think relevantly for our discussions. I think as the older persons treaty negotiations progress, having a clearer lane for delegated decision-making would be really helpful because it would, in the first case, avoid some of the controversy that surrounded the adoption of the CRPD and might make it easier for governments who haven't forgotten, basically, that they might have bit off more than that they intended to chew with regard to ratifying the CRPD, that there is a less perhaps transformational option or path for achieving compliance with an older persons treaty that does affirm the right to legal capacity of older persons. And that it also might correspond more appropriately to some of the concerns and the context of older persons, which are distinct from those that have informed the disability rights movement. And I see that I'm running short on time, so just by way of summary, I would say the disability rights movement has been very, very concerned with rights preservation, but the advocacy organizations and the movement for the rights of older persons might be more inclined towards right outcomes rather than so kind of the optimizing for the good decision-making outcomes as opposed to maximizing and the protections of the decision-making process that have been central to the advocacy efforts around people with disabilities. So with that, I'll yield back the microphone, and I'm looking forward to the discussion. Thank you so much.
So we're going to now move into discussion. As you know, this is very much a writer's workshop, so really we've got a tremendous collection of brains in the room, all of them aging, and beautifully so. And so we're really looking for feedback, critical, right, taken in the spirit of collaboration. We're all in this together. Before I open it up to the entire group of us, I wanted to also give the panelists an opportunity to pose questions of each other. So let me just invite that now. Julia? And I just ask everyone to speak into the microphone, also so that our colleagues online can hear as well.
Thanks, Nina. I've got a question, just if anyone would like to answer it, or especially those people who've talked about advanced directives. And I'd just like to say how much I enjoyed everyone's talks. This is I don't know the answer to this question. This is why I'm asking it. But advanced directives, I think, I agree, they're very important. But how someone in that video said she's not herself anymore about his mother, and I think we all understand what that person means. But there is this idea that we, in the dementia advocacy community, of transformative personhood, that just because someone has dementia, it doesn't mean they're not a person anymore. They're a different person, and their values and preferences might have legitimately changed to in a way that grieves their relatives. But I just wondered if anyone had any insights on how we deal with that very difficult question of what's being called transformative personhood, and when there is in particular a conflict of what their preferences or values might have been beforehand and what they are when they're lost formal legal capacity. So I just thought I'd throw that in there because it's such a difficult one. Thank you.
Leslie, do you want to respond?
Yeah, I'll say two things about that, with the preface that I think it's enormously difficult. But one of the things that I think some of the more recent research, and I'll invite you to comment on this actually, is that when preference changes are the result of capacity changes, how do we want to think about those? Do we want to think about those as themselves impaired changes, or do we want to think about them as genuine changes? There's the other thing is that there's this whole debate about present self, past self, and part of what always seemed wrong-headed about that is that people were saying, well, my advance directive for healthcare shouldn't govern, without thinking about, well, does that mean my will doesn't govern? Is my advance directive for healthcare somehow different from everything else, the property arrangements, all those kinds of things that I've done? And what that raises for me is that we might want to think about whether all changes are alike as well. So, maybe we want to respect, excuse me, I don't know why my voice seems to be going, but we might want to respect changes right now that have to do with whether I'm comfortable or what I am enjoying, but not want to respect in the same kind of way the decision to give somebody a big gift, a big financial. So anyway, I'll raise those 2 points.
Duke?
Yeah, it's a really great question. I'm sitting here thinking, from my perspective, I come from the medical world, so there's always a sort of a disease sort of overlay to how we think about things, or disease versus absence of disease, or health versus not health. And so your point about there, maybe it's the decision itself and what it's implying. And I guess for me, since I'm in a world where we think about pathology so much, and I think one of our ways of thinking about it is that pathology can change decisions. I guess for me, I wonder if that would be the indicator. So if someone changes their mind about something or a decision, but there's no pathology or or evidence of pathology in the brain or a disease, then I would say, well, that seems to be like a freely determined decision that is different than is normal. But if there is the presence of pathology, then I think, there could be some rationale for saying, well, maybe this decision isn't coming about in truly the best circumstances. But I know that's hard to determine in reality. So I guess I'm really just sort of sitting in these great questions and trying to think through them because I never really thought about it before, and it's partly a philosophical question, but I think those are just some thoughts I have right now.
Let me invite any other members of the panel if they have questions that they want to pose. Erica?
I just want to say, I don't think legal is really good with the gray. Like, we like to think in terms of black and white. And I think, again, we're moving towards, embracing the gray, especially with a lot of these new updates that we're seeing kind of, again, with the updates to the Uniform Healthcare Decision-Making Act. But again, we're still slowly making our way towards that. And I think that that's kind of where we're at, right? I mean, I have been doing a lot of work in the area of supported decision-making and some of these other areas too with advanced healthcare directives. And I do think that it's hard because we get these questions a lot that come up with, can older adults that have dementia do have advanced healthcare directives, and can they do supported decision-making agreements? And it's hard because, we come up with these, as we talked about, just because a person has a diagnosis doesn't mean that they can't. So we do have to really recognize that there is areas where there is capacity, even with a diagnosis. And that's where we really rely on medical and where they can, provide us guidance within these shades of gray. But again, legal is definitely not embracing the shades of gray. They're very much more about the black and white.
Yeah, and just a quick follow-up, and I think that's a great point, that, and for what it's worth in my own sort of circles on the medical side of things, we do assessments for capacity and decision-making, and we do find that people with a mild dementia do have capacity and intact decision-making. So there are these sort of, variations that need to be appreciated, and it's not all just because someone's been diagnosed with Alzheimer's recently, they don't have capacity. I would very much argue against that because a lot of our research has shown that that's actually not the case, that a lot of them do, actually. So in some ways, it just complicates things further, but I thank you for saying that, and I just wanted to reiterate that that's absolutely something that is appreciated on the medical side of things as well.
So I want to make sure that we can open things up and get some questions and thoughts from everyone here. So if you would like to join in, I see we have some raised placards. I also see that my vision is really lousy in this room. So can we start with Richard Kaplan, who's had his, I believe, sign up for a while, and then we will move around.
Can't do that myself.
The question is, how much of this is just a fear of numbers in this tough of the numbers, like pre-existing
Yeah, I think to your first question, I think it is something that I think the clinical evidence could be something that could be helpful in a court situation to help determine guardianship. At least I feel like it has been done in the past, and I think it helps to inform decisions. There's no one correct way to go about it, so I think just more information is helpful in that regard. Your second question about the numeracy, that's something that's been brought up to me a lot, and successive generations, I think, do have less sort of practical interaction with numbers. It remains to be seen how much that actually does have an impact on financial decision-making, I'll say, because our financial literacy measure includes semantic knowledge also. So it's not just numeracy, at least based on what we're seeing. And in other research, we've adjusted for like arithmetic ability and that sort of thing, and it doesn't seem to be as big of a factor, I'll say. And then the third point about, intervention, yes, thank you. So that's something that's on the forefront of our minds at all times. So we do think that interventions that help promote financial literacy do help financial decision-making, I will say, even at any age, actually. That's something that a number of people in the field are doing research on right now. It does seem to be the case that programs that help bring awareness about scam and fraud seems to help, at least at a global sort of population level. So interventions do help. And I think we're just constantly trying to think about, from a neuroscience perspective, what are ways that we can sort of buffer certain brain networks that will help people make better decisions. So in the case of what was presented in the video, for the entorhinal cortex, which is a bridge brain region between two different networks, we're thinking about how to sort of buttress the connections or the communication between those two different networks by stressing what's important on those two sides of things. So trying to bring prospective memory online more, and also value, basically trying to stress those things in adults who may not be able to appreciate those, or at least, yeah, so.
Just one brief follow-up on that last point. Wonder if you want to comment on the recent trend in the financial industry trying to bring in co-decision makers. For example, long-term care insurance policies now have as a prototype that if you miss a payment, they automatically contact someone else.
Yes.
And others that Fidelity will have these kind of backups if they suspect things.
Sure, yeah. Yeah, and so the question was on sort of support programs from financial institutions for having a second decision maker or a second person involved. And overall, we generally see that as helpful, just because, just from the elder abuse work that we're familiar with, the more socially isolated someone is, the more that there could be a potential for financial exploitation. So in general, we do find that something like that could be helpful, with the caveat that a lot of financial exploitation is also committed by a close family member or loved one. So, so it's, in general, it's helpful, but that additional person who gets notified really needs to be selected well. Yeah.
Could I just add something to your point about evidence? Because when some of these issues get into litigation, it's about a decision that was made, say, a year or 2 or 3 years ago, when there might have been the diagnosis, but that's it. So we don't actually know what the capacities were at the point in time when somebody changed their durable power of attorney or gave a big gift to their granddaughter who was their caregiver, and the granddaughter is now being accused of abuse. It might have been a genuine preference gift, or it might have been a diseased capacity, undue influence, and all we have at the litigation point is the diagnosis. And that's another huge legal problem.
So I see we have a tremendous number of people interested in commenting. So what I'm going to do is ask our responders to try, to the best of your ability, to limit yourself to a 2-minute response. I'll actually put on a light for that, just so you have a little bit of guidance. Adrian, do you want to be next? No.
Unlike this?
Yes.
Sorry. Thank you. So I thought what you said about financial literacy moderating the effect of race on decision-making is very interesting, and I hope you would also include computer literacy, because of course these financial scams have become much more sophisticated and can draw in people even if they're not elders, and even if they have no cognitive impairment. And as a physician working in a basic science department that focuses on neuropharmacology, and I also direct Farmed Out that does research on unethical pharmaceutical marketing practices. We've done quite a lot of work on MCI and dementia drugs. So I also just wanted to comment that MCI is an extremely squidgy diagnosis that, of course, can be caused not only by brain dysfunction, but also depression, fatigue, medications, underlying medical conditions. Perhaps with Hezi new parenthood, you might not pass a test today. And it's often stable. It often reverses. It's a very, very squidgy, a very squidgy condition. And I would also just warn everyone about depending on imaging tests or now blood tests for dementia, that there is a move on to diagnose completely cognitively normal people with early Alzheimer's disease based on blood tests, which is completely outrageous and wrong, and is going to be really damaging. 50% of cognitively normal elders have amyloid in the brain and will come out positive on these blood tests. The vast majority of those will never develop any level of dementia.
Thank you. Any responses or?
Oh, I'll just say I agree with your statement on the blood test for Alzheimer's, and I think it's an ongoing that's a whole other issue we can talk at length about. There's a lot of pro and against that approach. So, and I do also just I agree that technology literacy, and really any literacy that helps to inform a decision, I think would be important, actually, given whatever the decision is. So wanted to reiterate that point. And this has come up before, the diagnosis of a condition and whether or not that's enough to actually determine if someone's incapacitated. I don't think that that's the case. So, so thanks for those comments.
Okay, Bridget?
Thank you. I am also a trust and estates lawyer in another life, and so I wanted to offer to everyone a very gentle footnote that the whole notion of capacity is very, very legal context dependent. And Julia alluded to that, Leslie alluded to that, that the legal definition of capacity for purposes of making wills is very, very different. It's much more fluid, much thornier, and we don't really think the medical profession should have anything to do with measuring mental capacity in the wills context. So I would just offer that as a gentle footnote as we're talking about delegated decision-making, substituted decision-making, that the wills, trust and estates area is a wonderful counterpoint in many ways. It's by no means a model, but it just complicates the analysis a little bit.
Julia?
Thanks. Thanks for the question, Bridget. Just on a side note, Rosie Harding in the UK is doing work on supported decision-making with wills. And I'd just like to say that I suppose what I was saying before with the Australian sort of guardianship supported decision-making legislation, we're also veering away from sort of, there's always medical evidence, and the medical evidence can often be determinative, but sort of human rights, civil rights type lawyers are moving away from having that medical evidence as determinative of capacity and really seeing people in their social context. And that's really consistent with the idea of supported decision-making, where you can bring, it's not just about having, for instance, particular family members there, which can be problematic with wills, conflicts of interest, but to support people or support workers to support people with their decision-making. But it's also about, particularly with fluctuating capacity, given it's a part of a dementia, making sure that it's a time of day when that person has optimal cognitive capacity and when they're in an environment where there's not too much stimuli around them to distract them. So I would, I think, just in quick response to Bridget, I mean, absolutely, I'm not a wills and estate lawyer. There are differences, but sort of social model of disability would really veer towards not emphasising or having central that scientific and medical evidence. And the other thing about it, of course, once medical evidence is, or scientific evidence is brought into litigation, it can be a black box for those in the room who don't have expertise, and can also lengthen litigation and make it more expensive if you're getting lots of expert witnesses around. And that means there's a lack of access to justice for people who want to revoke a guardianship order, contest the bona fides of a supporter, any of that sort of redress that people might need or wish to access in a legal forum. Thank you.
I'll just,
I was just going to say, there's something lovely about the common law poetry, knowing the nature and objects of your bounty.
I will just say, as a trust and estates professor and someone who does this other stuff, I think, you know, there isn't quite this trust and estates exceptionalism anymore on capacity standards. Well, you know, what Erica and Jessica were talking about with the Uniform Act, in part, is an effort to create clear capacity standards and clear metrics in the way that we have historically seen with capacity to create a will. And so part of the movement in this area, and you know, we might ask whether it's a good movement, is trying to recognize that domain specificity and creating clearer definitions in different domains, a la T&E. Thaddeus?
Nina, just to interrupt for a second, because we have about 15 minutes left, I wonder if you want to get a bunch of questions sort of out, and then we'll move to this.
Great. Let's do Thaddeus, Allison, and Tara.
All right, thank you. So I believe that we have an enormously high false positive rate in terms of saying that people are incapacitated when they're actually not. So I heard several times, you know, the binary, we're too binary. And so and maybe this is for Jessica and Erica, which is, I wonder how much of Leslie's point is a cause for that, which is this fragmentation of statutory schemes. So I think now maybe 30 states have supported decision-making statutes, but they're separate, right? They might be linked to the guardianship statute, because at least the probate judges are trained to always exhaust everything else before or maybe not even that, but at least they're better trained than the attending physicians, who may jump to the advance directive or jump to the agent or jump to the default surrogate without exhausting something like supported. I'm not even sure many are aware that there is such a thing as supported decision-making. And then the second last point is, I wonder how special, because everybody talked about supported decision-making, but how special is that? Because there's other things that we also don't exhaust, like, does this patient have limited English proficiency? Is that why she doesn't understand and appears to lack capacity? Is the patient have a hearing impairment? Is that why she appears to be incapacitated? You know, have we used, you know, teach back? Have we used decision aids? Have we, you know, so we even done quality informed consent, and so we're reaching a judgment of incapacity. So I just wonder, is supported decision-making really so special, or is it just one of a number of tools or things we should check before we conclude incapacity and start moving to alternatives?
Allison?
I just wanted to mention and maybe get some of your reaction to bringing in kind of a civil rights framework and pointing out that when the U.S. Department of Health and Human Services updated the civil rights regulations in Section 504, specifically brought in supported decision-making as a reasonable modification and accommodation that's required for any recipient of healthcare funding. And I don't think people yet know about it, but really thinking about how that might be potentially a driver of change or not, particularly in light of some of the comments, Hezi, that you made about kind of the ways that disability rights maybe has been too binary, but also looking at some of the work you've done, Erica, and how states are moving to a little more of a rights-based focus.
Great, and I'll be brief. I know that there's lots of questions to answer here and more questions from the group. But I was really struck by what you were trying to achieve in your paper, Leslie, with thinking about the ways to really allow for more of these nuances, the triggering events, the arrangements. And I was wondering about, we do have the 5 wishes and that type of template where people can really write in like very specific arrangements they'd like to have, and that is adopted and recognized. And I thought that might be an interesting approach to consider given the wide range, and love to hear your thoughts on it.
Okay, let's give our panelists 1 minute to respond to anything they want to. Leslie, did you want to quickly respond to that one or any of the others?
Yes, yes, and yes. And the wishes document actually, it's specifically in the realm of healthcare, but I think it would be very interesting in the realm of finances or where you're going to live as decisions that are particularly important decisions.
Other people on the panel who want to respond to any of those 3? Yeah, Erica?
With respect to supported decision-making, I do think that this is a tool in the toolbox that we can use going forward. I do think that it is something within the medical profession we do need to see a lot more probably education and just knowledge about, because I've worked on projects that have shown that even within the legal communities, we still don't see a lot of information and general knowledge about it. So yes, we do now have more than half of our states that have adopted supported decision-making, either in some type of context or with the form of it, but at the same time, a lot of people still are struggling kind of to know like what it is and how to support people with it, so.
I would say also part of the issue with fragmentation, which both Bridget and Thaddeus, you've talked about, is one is the stage in the process. So, as an attorney drafting a will or a POA, I absolutely want a medical professional far away from that decision about whether I have a client. But that's a capacity decision about the ability to execute a document. That's, a different stage in the process than now I'm in the ER. Can I decide whether to consent to this treatment or take this med or stop taking this med? So I think that the stages in the process complicate decisions. And I also think who the decision maker is can explain some of the discrepancy, which is something we address in the paper. For example, an individual subject to a guardianship, as Thaddeus, you said, it's a judicial officer deciding whether that person has capacity, which could include the capacity to make a medical decision. Take that same person, and instead of a guardianship, they have a healthcare advance directive. Now it's a medical professional deciding whether that person has the ability to make the same healthcare decision. So you have the very real reality that the same person in the same circumstance would have 2 very different sets of legal rights based on who the decision maker is with respect to their capacity.
Susanna, do we have people online with questions? I'm just trying to pace time. Let me know as we go through. We're going to take another set of questions. Is it Ito? I can't see.
Yeah, it's Ito. Thank you. So this kind of foreshadows our presentation, but one thing that I've been thinking about is, and this is a question for the panel, is, we think about these capacity questions through the lens of law or philosophy or medicine, but oftentimes you have couples where one spouse is significantly older than the other. It's usually the male that's significantly older than the female. And in exercising their own ability to make decisions about, say, staying in the house or staying in the community or receiving round-the-clock care, because of our healthcare system, they're constraining the decision-making of the spouse. In other words, the money's going to be gone by the end of the time that they make all their decisions, and the caregiver's needs are going to be really constrained. How or is that relevant in considering really the community rather than the individual? Now, I know that's fraught, but it's something that's on my mind, so I thought I'd ask it.
Thanks. Sharona?
Thank you for those excellent presentations. I want to just push a little bit more on the capacity issues, and I'm wondering if any of you are working on this, because even the medical professionals don't seem to know how to make those capacity decisions. I'm on the ethics committee of University Hospitals in Cleveland, and we all the time have doctors that say, this person doesn't have capacity, and we ask questions. Yes, he knows what day it is. Yes, he knows what he wants to eat, but I still don't think he can make medical decisions, and the ethics committee just accepts that. And so even the medical professionals are in chaos and not that helpful.
Andy?
So it occurs to me that for some purposes, like resolving disputes over wills, it would be desirable to have two measurements of capacity. One that's historical and was sort of put in escrow for the future. When a dispute arises, you could take another measurement of capacity and compare the two. I wonder if you'd comment on the desirability and feasibility of that.
Great. Let's jump back to the panel. Responses that anyone wishes to provide, any of those? Duke?
I'll just say from a neuropsychology perspective, we think of cognition in the same way, where if it's actually best not to do the cognitive assessment when there's problems, and ideally when there's no problems, you'd have a baseline to compare it to. So your question about capacity could be a similarly informed a situation where if there was a sort of a baseline sort of preferences and wishes, that could be referenced to it once things change actually down the road, unless they do genuinely change, and then I guess you have a whole other issue. So in terms of the question about medical professionals not having a consensus for capacity, that's true. There's no consensus. I'm on a number of working groups right now that are trying to build that consensus. But I think it is, I'll just share it from my own opinion. I think it's a problem if a doctor is just sort of asked, because doctors will have different opinions on what they consider as capacity. So until we do have sort of a uniform way of doing this, I think that issue is always going to be there. So just some thoughts.
Julia?
Ito, I think your question was about if people don't really have choices, without sort of resources to make choices about accommodation or healthcare, then, what does that mean about capacity? And I think that's a really good point. And I think too often, this is getting into sort of bioethics and philosophy, but, autonomy and capacity seem like a 0-1 option. Am I allowed to, should I, dare I say, have a choice to have an abortion or not have an abortion? That's sort of 0-1 option. But if we haven't got resources, if we haven't got access to medical care, if we haven't got access to good accommodation, it's like asking a homeless person, would you rather sleep in the street or sleep in that dingy hostel where you're going to get all your goods stolen, you know. They don't have an option of living somewhere where they might want to live. And there is a whole body of literature in bioethics, relational autonomy literature, which says you really need the social and economic conditions, preconditions for autonomy. So I sort of always think that that's really important, that when we're talking about, you know, choices to do this and choices to do that, we're talking about probably our very privileged middle-class lives, let alone, you know, the global south. So I just like to say that I think it's a really good question, and that the poor carer in that situation, I mean, she hasn't got much choice, has she, except to get extreme carer's fatigue? And what about her autonomy? So I haven't answered that question, but I think it's a really good question to keep asking, and really complex solutions for that one. Thanks.
So another addition to that is that often the planning choices that are made, including for healthcare decisions, such as who is going to be the durable power of attorney or who's going to be the power of attorney for healthcare, are choices that are not made by individuals in silos. And this goes to Andy's point. They're made often by couples or by families planning. And so then when we have the later question of respect for those choices, it may be mistaken to just see it as now the individual in the silo.
So I want to take two final questions. Just a note to Sharona's question, piggybacking off Bridget's and Erica and Jessica's presentation. You know, when we talk about doctors not being able to figure out, like, is this capacity, just note that as lawyers, we've put doctors typically in an entirely untenable situation, in that in most states, there is actually no definition that the doctor is to judge against legally, which is the reason you need to adopt the Uniform Act. Okay, Govind, and then Marie, MT.
Great. So my question, I think, follows from Julia's on the panel. So I'm interested in sort of a concrete sort of case that explores this sort of change in values or change in identity or whatever problem. So say you have clearly at time one in the past, selection of some supported decision-making process, selection of a supporter, expression of values, and so on. You can be very epistemically confident that that's what was selected. Then later, at the present time, we have what looks like a less clear dissent from that designation or process. We're not as epistemically sure, but maybe we think more likely than not, it does look like they're dissenting. I'm curious for those who spoke to this in their talks, sort of how you all think law should analyze this kind of conflict, how ethics should, and in practice, do you think people are going to be willing to override a contemporaneous, even if unclear, dissent? And if not, then what does advanced designation mean? Are we sort of holding out a promise to reassure people that shouldn't actually be reassuring to them because it won't be followed?
Thank you. MT?
I really appreciated the conversation between Julia and Leslie about, is it what you want now or is it what you wanted before? And it made me think about a case that an adult protective services worker told me about a woman who was in a nursing home, very incapacitated, and her kids went to him to say, oh my God, you know, Mom would never have gotten in bed with another woman and now she is. And the staff said, and very happily. And so the question was, if they're in the position of being the deciders for her or the supporters, how do we train people? And so I'm curious because my understanding is that supported decision-making has been around for a good while, especially in the context of developmental disabilities and the like. It's newer for dementia, and it's a complicated business, and how do we train people, especially on these really profound issues that have to do both with the variability of dementia, but also the profound ethical questions?
Any brief 30-second responses before our time expires?
MT, it's sort of outside of my sphere in a way, but I do work with the Disability Centre, Research Centre in La Trobe University in Melbourne. And they have a framework, and I think the key part of that framework, 'cause it's got so many steps as things do, is that self-reflection that children or supporters have to have after they help them through a decision. To what extent have they imposed their values on that person? And it's that sort of reiterative self-reflection about the process, because it can be very intuitive for relatives to be, benignly paternalistic, or in that case, it's really fraught. But that sort of training for the supporter is really important, and there are a few pilots around. Thanks.
So one thing you can try to do is let people specify in advance whether they want directives to be changeable, as with mental health directives. And there's a great paper by Agnieszka Jaworska on the capacity to value that's relevant to your point.
Well, I want to thank our panelists and also our entire discussion group here. So can we give them a round of applause?
Thank you, Nina.
We are now going to meet for the photo. Just let me say, though, that this is really the beginning of a discussion, and I really encourage you to continue this discussion and continue to provide one another with feedback. That's what will make this a fabulous project.